The waiver of immunity of Mr. Puigdemont, Mr. Comín, and Ms. Ponsatí has been requested by Spain's Supreme Court, which is not the competent authority to make the request. The competence of the Spanish Supreme Court has been contested from the beginning of the case because, in accordance with Spanish law, the alleged crimes ought to be judged by a court of the territory where they were committed, in this case, by courts in Catalonia. In this regard, on January 7th, the Brussels Court of Appeals confirmed the refusal to execute the European arrest warrant against the former member of Catalan government, Lluís Puig, among other reasons, because it considers that the Spanish Supreme Court is not the competent court to try the criminal case. This ruling by a Belgian Court of Appeals, which is final because it has not been appealed, gives even more force to the arguments against the competence of the Supreme Court. To support this decision, the Belgian court has taken into account the resolution from the UN Working Group on Arbitrary Detention, which had already declared the incompetence of the Spanish Supreme Court to judge the case of Catalan leaders currently in prison. Since the Spanish Supreme Court is non-competent, the immunity procedure is invalid and must therefore be interrupted. Otherwise, if the waiver of immunity of Mr. Puigdemont, Mr. Comín, and Ms. Ponsatí were to be approved, this decision could be easily contested in the European Court of Justice. The Spanish Supreme Court had taken the case because the three MEPs, given their positions, could not be judged by an ordinary court. However, the Supreme Court issued the waiver of immunity after the 27th of October 2017, and the three MEPs stopped being government officials on October 27, 2017. Therefore, their case should be judged by a lower local court in Barcelona. Protect the European Parliament. Protect their immunity.